welcome to today's program, Policy Limit Demands, the New Legal Landscape, CACI 2334, CCP Section 999, and beyond. I'm Ala Policastro, Director of Education and Professional Development at Beverly Hills Bar Association, and today I am delighted to introduce our speakers, Arnie Levinson, Peter Klee, and Daniel Eli. Arnie is a mediator with Signature Resolution. He brings nearly 40 years of legal experience and close to a decade in mediation to his practice. He's a nationally recognized expert in insurance coverage and bad faith law, with prestigious industry awards that are far too many to list here today. Peter Klee is a partner in the business trial practice group at Shepherd Mullen, based in the firm's San Diego office. Over the last 4 decades, Peter has handled over 3,000 bad faith cases, including dozens of jury trials. Peter is a member of ABOTA and a fellow of the American College of Trial Lawyers. He's also a co-author of the Rudder Group's Insurance Litigation California Practice Guide. Last but not least, Daniel Eli is of counsel at Paris Law Firm, where he heads the firm's insurance coverage and bad faith practice. He has devoted his almost 30 years of practice to disputes involving insurance coverage and bad faith. Dan's phenomenal results have earned him recognition in the prestigious Southern California Super Lawyers list since 2011. We can't wait to hear what they have to share with us today, so I'm going to turn it over to our speakers.
Thank you. We're lucky to have both Peter and Dan here today, who are outstanding experts in this particular area of policy limit demands. We're going to go through the presentation today, and we're going to focus on two sources of law here. We're going to focus on CACI 2334, which is a CACI instruction on third-party policy limit demands. And then we're going to talk about CCP section 999 to 999.5, which is the relatively new statute for policy limit demands, which are prior to litigation. And we'll be going through that statute. And as we talk through that statute, we'll break off and talk about some of the key issues that are in the statute and that also relate to policy limit demands during pending litigation. Let me get the PowerPoint presentation up here. So first, we're going to start out with CACI 2334. I put a snippet of CACI 2034 in here. These are the three things, or the two things that we're going to be concentrating on in this presentation. The first is that a claimant the claimant made a reasonable demand to settle within his or her policy claim against the insured for an amount within policy limits. The insurer failed to accept the settlement demand, and the insurer's failure to accept the settlement demand was the result of unreasonable conduct. We've sort of broken this down into two areas. One is a reasonable policy limit demand, and the second is the unreasonable conduct of the insurance company. You've got to establish both at this point, and Peter, a little later in the show, is going to talk about the history of and development of this CACI instruction. The pre-litigation statutes apply to demands that started on January 1st, 2023. And we'll look at this statute. The first part of the statute says a policy limit demand must be labeled as a time limit demand or refer to this section, and it must contain the following items, which are fairly significant. The time period has to be 30 days, or if it's 33 days by mail. You can't have a shorter period of time than 30 days for a pre-litigation demand. It's got to be a clear and unequivocal offer to settle all claims within the policy limits, including the satisfaction of all liens. And we will talk about that concept also a little later in the show. An offer for a complete release from the claimant for the liability insurers insureds from all present and future liability for the occurrence. Again, we'll talk about that a little later in the presentation. Date, location of the loss, the claim number if known, and then these two items are very significant. A description of all known injuries sustained by the claimant, and then probably the key provision is reasonable proof, which may include, if applicable, medical records or bills sufficient to support the claim. And note that this section says may include, it doesn't say shall include. So there's a question of what exactly is required under this statute, and Peter and Dan are both going to talk about that. So this brings us to the question of what is a reasonable demand. And for that, our first topic under this is what supporting evidence needs to be submitted for a reasonable demand. And Dan, I'm going to turn it over to you at this point.
Thanks, Arnie. As a caveat, just to go back to Section 999, just point out again, it applies pre-litigation only, so it does not apply to litigation settlement demands, and it only applies to policy limit demands by attorneys. Does not apply to policy limit demands by individuals. And so when we're talking about this, that's what we're talking about is pre-litigation attorney demands. What supporting evidence needs to be submitted? I maintain, and given the nature of my practice, of course, I maintain that it really depends on the circumstances of the case, and depending on what information the insurance company knows, what information is available, you may not need to provide very much. Some of the cases that are up here on this slide, I'll let Peter discuss them, but I don't think they reflect the correct, most of them, all of them are federal cases. I don't know that they reflect the correct California law on the issue. We can address that when Peter gets into it. But the bottom line is, you're really looking for reasonableness. Does the insurance company have enough information indicating that the loss is likely to exceed or substantially likely to exceed whatever the formulation is, the policy limits? And that's really what the statute gets at. The insurance company has to have sufficient information from which it can conclude the value of the claim exceeds the policy limits. And Peter, if you want to,
sure. Let me jump in on. Let me jump in.
Some of these are Peter's cases.
Well, look. Let me step back for a moment and talk about why 999 was enacted. It was enacted by the legislature in California, which everybody knows is a very liberal, pro-plaintiff lawyer legislature, but the legislature itself recognized that there had been some abuses going on in this area of the law, and they enacted the statute to address those abuses. And the interesting thing about the statute is it didn't really create any new law. It's really a codification of the state of law that existed before the statute was enacted, but it made it very clear what those rules are regarding settlement demands and what needs to exist and what not exist. So, for example, Arnie just talked about the fact that you have to identify all the known injuries. For those of you that have been practicing in this area, you all know that there are cases where you get a policy limit demand where the claimant intentionally conceals the nature and extent of the injuries because they don't want the insurance company to know that there are significant injuries, because they know that if they inform the insurance company of that and they back that up with actual medical information, the case will settle for the policy limit. And that's actually a bad thing if you're a plaintiff lawyer that has a catastrophic or serious injury case in which the limits that are available are well below the total amount of the damages. So what happened is a lot of plaintiff lawyers were engaging in tactics to try to lull the insurance company into not accepting a policy limit demand in a case in which the damages vastly exceeded the demand. And so the 999 was enacted in part to address some of those problems. And the two provisions that Arnie talked about a moment ago, that he said were among the more important ones, were basically providing the insurance company with information that is known by the claimant's attorney, and also providing medical records to back up that information, because you can't just make a demand and say, either hide the nature and extent of your client's injuries, or make claims that the injuries are super significant, but not provide medical information that actually backs it up. Insurance companies aren't required to rely on uncorroborated assertions of medical injury. And so that was a big problem, where they would get claims that the claimant had suffered a brain injury, but there would be no medical records to support it. And a lot of insurance companies were sued for not accepting policy limit demands under circumstances like that. So this statute addresses that situation, and it requires that the claimant attorney disclose the true nature and extent of the injuries, and ordinarily that support those with corroborating evidence, which ordinarily would mean medical records and bills. Now, the cases that are shown on this screen, McGranahan, Capital Specialty, and Spradlin, are cases where the insurance company was not provided with actual medical information that corroborated the claimed injuries. And the courts in those cases held that that was not a reasonable demand, and the insurance company was not obligated to accept it because they are entitled to medical information. And just stepping back for a moment, just ask yourselves, why wouldn't an insurance company be entitled to the actual medical information that supports a claim? I mean, it's a pretty basic element of a claim for personal injury. Insurance companies, at least we argue and have successfully argued, are entitled to that information, at least enough information to show that it's worth the policy limit or more. And if it's not provided, then they shouldn't be held liable for not accepting a demand that's not supported by that information.
So,
Yeah, I would just, I'm going to respectfully disagree with Peter that this statute was somehow the legislature's response to a need in the legal field. If you actually trace this piece of legislation back, it was enacted as part and parcel with raising the minimum liability limits from 30,000 to 60,000. I wasn't involved with the statute, but my understanding is it was basically a deal made between the plaintiff's bar and the defense bar, the insurance companies, that the insurance companies would not object to raising the limits, and the plaintiff's bar would not object to the statute. I think that's what drove the statute. I also disagree that the statute codifies existing law. It doesn't. Nothing in existing law required a 30-day acceptance period for a policy limit demand. Nothing in existing law said that a request for additional time doesn't constitute a rejection. This statute was drafted by the insurance industry to protect against open limits claims. And I do think the statute does change significantly California law, because there's a thing called a duty to investigate. An insurance company owes its obligations not to the claimant, not to the person that's injured. They owe their obligations to the policyholder. If you're an insurance company and you get a police report that says the claimant has been rendered a paraplegic based on the police department's investigation that places the insured at fault for the loss, why would you need medical records or medical billing to determine that the loss exceeds $15,000? You don't need any of that information. Based on the information that you have, it is clear that someone that's in a wheelchair, paraplegic, quadriplegic, if there's been a death, it's clear that the loss exceeds the policy limits. And I think that's why the statute's written the way it is, by the way. It's, reasonable proof. It's not medical records. If the statute required medical records, it would have so provided. It's reasonable proof of the value. And some of these cases, like, for example, McGranahan versus Geico, is a case where you have, I believe it was a motorcycle accident. I believe it was $100,000 in limits, but it was a Prop 213 case. And the insurance company, Geico, was attempting to find out what the medical specials were, because under Prop 213, you can't recover pain and suffering. It's only your special damages. and couldn't get that information from the claimant, including after a policy limit demand was made. And there the court said, look, without medical billing information, the insurance company was reasonable in not accepting the demand. Capital Specialty was a similar situation. It was a Prop 213 case, horrific accident, but Prop 213, the insurance company attempted to get medical billing. It couldn't. And I believe in Capital Specialty, they actually had medical records indicating that it was a severe injury, but the court said, look, they needed medical billing to assess whether it's worth, I want to say in that case, it was a $50,000 policy. And so what is reasonable, what is required is necessarily going to be based on the individual facts of this case. In Intagon Preferred Insurance versus Saavedra there, that's an order denying a motion for new trial by the insurance company. And a similar argument to what was made in McGranahan and Capital Specialty was made in Intagon. Carrier said, we didn't have billing records, we didn't have medical records, and therefore we couldn't accept the demand. And Judge Wu of the Central District said, no, you had other information. It was clear that the case was worth the $15,000 and denied the motion for a new trial after a jury verdict finding the insurance company acted unreasonably. And so what I was getting at is there are statements in McGranahan and Capital Specialty and in Spradlin to the effect that without medical billing or without medical records, it is not a reasonable demand. You have to consider all those statements in context of the facts of the individual case. What is reasonable proof in one case may not be necessary in another case, just given the facts of the loss.
And I won't belabor this point. I agree with Dan that you do need to look at the individual facts of a case to determine what an appropriate outcome would be. But the general rule that medical records, that an insurance company is entitled to them, I think has been recognized over and over by courts. In the Intagon case, where, as Dan mentioned, the court said that they didn't need the medical records. Well, the insurance company's employees in that case all testified that they didn't need the medical records in order to determine that the claim was worth more than the policy limit. So that case doesn't stand for the proposition that an insurance company that believes it does need medical records is acting in bad faith if it asks for them.
And lastly, before we move on from this slide, I'd encourage those who are interested to read the Ninth Circuit unpublished opinion in McGranahan. It was a 2-3 decision, 2-1 decision, sorry. One justice dissented, and that justice said, even under the facts of McGranahan, it should have gone to the jury. And so just, if anything, it goes to show you that, what's reasonable is subject to argument. And again, it's a very fact-specific analysis.
Right. So it sounds like what you're saying, Dan, is that there are situations where the insurance company might want further information because that's the way they normally do it. But you're saying that in certain situations, they have enough information, even though they want more information. They have enough information to know that it's a policy limit case. And in those situations, they don't have the right to go ahead and ask for more information that they don't necessarily need.
That's basically it. I mean, it really depends on what the insurance company knows, what's available to them. And a lot of this turns on the policy limit. If you have $1 million policy limit, obviously you need a little more information to justify it. If you have a minimum policy, 15 or 30 now, you don't need very much if it's a severe loss to justify paying the policy limit. So like I said, it's a highly factual analysis, and it's based on individual facts of each case.
I'm not sure you disagree with that proposition, Peter.
I agree with the proposition that if the insurance company has sufficient information to know its policy limit case, that it should tender the limits in response to a policy limit demand. But the issue is whether it's entitled to actual medical records corroborating the nature and extent of the injuries. And that's what each of those courts that are listed on the slide here found. The first 3 cases found that they were entitled to that information. They don't have to just speculate about what the actual nature and extent is and or what the medical billing is. They're entitled to actually get that information. And just stepping back and looking at it from a practical standpoint, why not just give the insurance company the medical records that show what the injury is? I mean, there's no reason not to do that other than to, be trying to set the insurance company up so that they won't accept the demand. And then you can argue that they should have known that the injuries were worth more than the policy limit at the time that they didn't accept the demand.
So do you think it's not a reasonable demand if, as Dan said, somebody's a quadriplegic or a paraplegic and you've got a 15,030 policy or a 3060 policy, that you would still need the medical records to make that a reasonable demand?
I think that if you have information showing that the claimant is a quadriplegic because of the accident, then you have an obligation to pay a lot more than $15,000 if your limit is higher than that. That my point is, though, that you are entitled to get information actually corroborating the nature and extent of the injuries, at least to the extent to show that they exceed the policy limit. In your hypothetical, Arnie, if they knew that the claimant was a quadriplegic because of the accident, then that's all they need to know. And that's the whole point. How do they know that? They don't know that because the lawyer said, my client's a paraplegic, or the claimant said, I'm in the hospital and I'm a paraplegic. They know that because they actually got objective evidence establishing the nature and extent of the injury.
Which would be the medical records, would be the primary objective evidence.
The primary. And I want to agree with Dan. If it's a wrongful death, maybe you don't need medical records because they're not going to determine what the injury is.
Right.
A death certificate would do that. But are you entitled to a death certificate or some other objective proof of the death? Yes, you are.
Okay. All right, well, let's move on. The next issue is whether all claimants need to be part of the demand. And I should modify that a little bit, and that to include whether all people that might be claimants need to be part of the demand. Dan, what's your take on that?
Yeah, I think in 991.1B there that you're citing, I think, yeah, absolutely. If there are multiple claimants, well, let me qualify that. It really depends on the policy limits. If you have a 1530 policy or a 3060 policy now, and you have two injured claimants, each claimant can make their own demand. Each can demand 30,000 because you don't have a limits issue, or you don't have a potential of exhausting the limits while leaving other claimants out there. So if you have, let's say, $300,000 policy and there are three claimants, each claimant can make their own independent demand without joining the other claimants in the demand. If, however, you have more claimants than per person limits, for example, on a 3060, you have three claimants. If you're going to demand the policy, you're going to need to join the other claimants, or there has to be some significant information out there indicating that the other two claimants, their claims will not exceed the other $30,000 policy limit. That's my take on it. So, for example, if you have three claimants that are injured, one person's in a wheelchair, the other two, soft tissue, they went to the emergency room and never treated again. I don't know that the person that's in the wheelchair needs to join the other two soft tissue claimants in his demand. That claimant's claim clearly exceeds 30,000. The other two don't. But it's a good practice if you have multiple claimants, more claimants than per person limits, to try to get everybody to join in the demand.
Peter?
I would point out that 999 by its terms does require that all claimants join. And the reason why that requirement exists is because insurance companies are not allowed to exhaust their policy limits on some but not all claimants, leaving their insured exposed to additional claims without insurance to protect them. So in the scenario where you have, as Dan mentioned, you have a policy with, for example, 100, 300 limits, 100 per person, 300 per accident. It may not be a reasonable demand for one of multiple claimants to demand one of those $100,000 per person limits if that will exhaust a portion of the policy and leave the insured exposed to all the other remaining claims. There may be circumstances where a court might hold that under a unique set of circumstances that is an appropriate demand, but at least under the language of the statute, that would not be an appropriate demand. You need to make sure that the insurance company is paying its limits and in return completely protecting the insured, and exhausting a part of those limits may not meet that requirement.
Yeah, I agree with Peter again in the situation where there are more claimants than per person limits. Also, just really quickly wanted to point out that 999.1B speaks to satisfaction of all liens, and where you have a workers' compensation lien or a Medi-Cal lien, Medicare lien, those all have to be satisfied within the same per person limit as a claimant. And so there, even though there's only one injured party, if there are statutory hospital liens, workers' comp liens, Medi-Cal liens, you have to be able to include all those in the settlement in order for it to be a reasonable demand.
We're going to talk about liens in a minute. I think that's coming up. But I have a couple of questions. What if you have, say you have 100, 300 policy and you have 3 claimants, or say there's 5 claimants and they're represented by different counsel. Do you have to get an agreement among all counsels so that you can submit one policy limit demand letter? Or what do you do if there's a dispute among the parties as to who's going to get how much of the funds?
I can answer that, or at least attempt to answer it, because the law is not crystal clear on that in California. The answer is, I mean, typically what happens is the insurance company itself will tender the limits globally to all the claimants. And if the claimants don't accept that, but they then want to make individual demands, they're facing an argument later that those demands were not reasonable and don't open the policy for the reasons that we talked about. So I've seen more recently policy limit demands that take that problem into account by saying if there are other claimants, then we'll agree to a global settlement for all the limits. And sometimes they say things like, we also want you to pay for the cost of a mediation between the claimants in order to determine how those proceeds should be allocated. So I've seen different things like that I think are attempts to address the problem. I'm not saying that necessarily requiring the insurance company to pay for a mediation after it's paid its policy limits is something that would be reasonable, but it is something that I'm seeing done in order to address the problem. But at the end of the day, we don't have a case that provides specific guidance on what to do in that situation. So what we have is the statute and the general principle that the one way you will open a policy is if you have claims that are worth more than the policy limits and you make a settlement offer for those policy limits that includes all claimants. That's the one way that you can be sure you'll open it. Anything else is open to debate at this point.
What happens if you have one person that is very seriously injured and the others are not? And there's a policy limit demand made by the person that's seriously injured, particularly if it's a combined single limit policies. Let's say there's 500,000 in benefits and payable. You get a $500,000 demand from the person who's very seriously injured, the argument being that for the insured, he or she is better off to accept that policy limit demand and be uninsured as to the small claims, as opposed to being exposed to the large claim that might come in well over the, say, 500,000 in my example limits. Would that trigger a bad faith complaint?
I think in that situation, my approach to it would be that the carrier has an obligation to disclose to the policyholder, which they do anyways. Insurance company has a good faith obligation to inform the insured of all settlement demands, not just policy limit demands. settlement demands, be they for below the limits or above the limits. And it's in your hypothetical, Arnie, I think the insurance company has to disclose that to the insured and has to explain to the insured, based on its investigation, to the extent it has the information, that the insured is facing significant exposure to the one claimant and exposure to the other claimants as well, although it appears to be that exposure can be a lot lower, and then put it to the insured to decide what they want to do. Allow the insured to make an informed decision regarding his or her own fate. And that's really, if you read the case law, regarding the duty to communicate settlement offers, that's really what the courts are getting at. The insurance company has to tell the insured about a settlement offer so the insured can make a decision, even though the insurance company fully controls the ability to settle, but the insured should have some input into his or her own financial well-being, especially in the case we have like a significant injury for one claimant and not for the others.
Right.
So let me just say, Arnie, that the point Dan is making, though, is that it's possible that under the circumstances you articulated, an insurance company could potentially face liability under a different theory, which is a theory relating to the duty to communicate with the insured. I do not believe, however, that the demand would be considered reasonable under the circumstances that you outlined, which I understood to be that one of multiple claimants demanded the entirety of the policy limit because that claimant was the most seriously injured. By definition, that would not be a reasonable demand. There could be a basis for other types of extracontractual liability based on duties to communicate to the insured, which is separate and apart from whether the demand is reasonable.
Right. And what the last question I had is, what happens when you have a claimant out there that hasn't made a claim yet, but is a potential claimant, an heir in a wrongful death case, or someone who was in an accident and was injured but hasn't made a claim yet? What do you do about that?
Yeah, that's a tough one. Because the claimants that are making claims in a lot of situations don't have control over other claimants that may be unwrapped or have no interest in settling. And the insurance company can sit back and say, look, we can't do anything until we get a claim or we get some confirmation by the other claimant that hasn't come forward that they're not going to come forward, that they're not making a claim. We've had those situations come up, and you have to wait. You have to look for the other claimant, or I think you have to present some evidence to the insurance company that the other claimant has maybe a minimal injury, minimal claim, and if your client happens to have a significant injury, that it would make sense for them and it would make sense for their insured to settle out your client, even though it may leave the insured exposed to a potential unowned claim by an unowned claimant.
So once the limits are paid out, there's no further duty to defend, is there, Peter?
There's not a duty to defend once the limits are paid out, and that's one of the reasons why insurance companies are not allowed to unilaterally exhaust their limits to settle out some but not all claims.
Are there circumstances where interpleading the funds would be appropriate?
Well, there's case law that says that interpleading funds, it is in fact an act of good faith. The Lato versus Allstate case says that. But interpleading funds is probably not the best way to resolve the case. If you can resolve the case by settling with all claimants and obtaining a release, that would be a preferable way.
Right. So you would think that tendering the limits would be sufficient without having the need to file an interpleader action?
I think that a tender of the limits or an offer to pay the limits, naming all claimants on the settlement check, is a form of informal interpleader.
Right.
So it's similar, and it requires them to agree how they're going to allocate it. So putting aside what demands the insurance company may have done. I think that tendering the limits to globally like that is, by definition, an act of good faith. The whole concept of bad faith in the failure to settle setting is premised on the theory that the insurance company is making an economic decision in which it thinks it can save money by paying less than the policy limit. And that just doesn't apply to a situation where the insurance company is tendering all its limits to all claimants. So that goes a long way towards insulating the insurance company from a bad faith claim if it does that.
Okay, so Dan, you mentioned liens. What does a plaintiff normally do in liens? Because I've seen a lot of policy limit demands where the plaintiff doesn't say anything about liens. And liens is specifically in the statute as we've read. But during the course of litigation when the statute doesn't apply, what's the situation in terms of whether you've got to put in the demand that you'll take care of any liens?
Yeah, I think we have to separate liens into two different types of liens. There's liens that are asserted by medical providers that are non-statutory liens. So not a hospital lien act lien, not a workers' comp lien, not a Medi-Cal, Medicare lien. Those lien holders have liens on the recovery. They don't necessarily have a right to subrogate against the defendant to recover their out-of-pocket. Workers' comp, Medi-Cal, Medicare statutorily are entitled to pursue the defendant, and in some cases the defendant's attorneys and the insurance company if their liens aren't satisfied out of any settlement. And so with the first type of lien, where it's just a provider, somebody went to see a doctor on a lien, that doctor's lien is against the recovery. So long as the demand says, hey, I will take care of that, I think you're okay. But if you have a situation, and Co and Gallardo are two examples of that. Co was a workers' comp lien. Gallardo was a Medi-Cal lien. Both workers' comp and Medi-Cal have a right of direct action against the third-party tortfeasor. And in the case of Medi-Cal, you have to take care of their lien as a part of the settlement. You can't just leave their lien out there. And so with those types of liens, you need to, and what I've seen on the Medi-Cal liens is the carrier will say, look, we'll settle with you, but we're not paying you until we get a final Medi-Cal lien, and we're going to cut them a separate check. Typically that's how that's handled. And with workers' comp, typically you'll get the comp carrier to join in the demand for the policy limits with an agreement to share the proceeds of any settlement.
Peter, what's your take on that?
I agree with Dan on everything that Dan said. The difference is when you're dealing with a statutory lien, you're dealing with a right of action by the lien holder directly against the insurance company, which is totally independent of any claims that the injured claimant might have. And so so the injured claimant has no right or ability to settle some other claimant's claims. I'm talking by other claimants, I'm talking about a lien holder who has its own independent right to go after the insurance company and the insured for the amount of the lien. And so any settlement demand that purports to settle the claims of these other lien holder claimants who have statutory rights is invalid unless those lien holder claimants join in the demand. And so this goes back to joining all claimants in the demand. So I see that's a rule that is honored in the breach more often than not, and plaintiff lawyers make demands that require that all the money be paid to them, and they do not. The demand does not allow the insurance company to cut a separate check to the lien holder who's entitled to a separate amount. And as indicated in the cases that you have up on the screen there, those are unreasonable demands, and the insurance company won't be liable for not accepting them.
So is it enough to say, for the demand to say, we will be responsible for all liens, or we will hold you harmless from all liens? Would that be sufficient, or do you have to actually have the lien holder join in the demand? Because getting somebody like Medicaid or Medicare to join in the demand would be pretty difficult.
Well, it isn't sufficient because they don't have the right to control the rights of Medi-Cal or workers' comp or any other statutory lien holder. It may be difficult to get the statutory lien holder to join in the demand. And so what the demand should do is have a carve out that enables the insurance company to satisfy the lien separately from the settlement with the claimant. And maybe that just involves getting more information from the lien holder so they can determine the amount of the lien. It may involve negotiating with the lien holder in advance of a settlement so that they know what the lien holder will accept and so that that obligation can be satisfied as part of the settlement. But to simply require that pay as a third party claimant to say, hey, pay me all the money and I'll take care of the liens, don't worry about it, that's not sufficient because that doesn't protect the insurance company from being sued by the lien holder. It doesn't protect the insured from being sued by the lien holder. You don't have to settle a claim that leaves your fate in the hands of an adverse third party claimant as to whether or not they're going to honor their obligation to satisfy liens or not.
Yeah,
Are you with that, Dan?
yeah. So I generally agree with Peter. And I was also going to note, going a couple of slides back, we had the claimants slide, and that we mentioned 991.1B, and that's why in the case of a statutory lien, the lien holder actually becomes another claimant to the policy limit. That's why there are multiple claimants in that situation. And there has to be, and I've seen creative ways of doing it. It's a case by case basis, but there has to be some resolution of that statutory lien as a part of the policy limit settlement.
So you have to get their consent to be part of the policy limit settlement demand then?
In workers' compensation, the way I've seen it is the comp carrier will assert a lien, and then you'll get them to agree to release their claim in exchange for the global tender of the policy limit. With Medi-Cal, typically what happens is there's an agreement to settle for the policy limits, and either the settlement amount is left in the carrier's possession pending resolution of the Medi-Cal lien, and then the insurance company sends a separate check to Medi-Cal and a separate check to the claimant. Or I've seen it where we've agreed to hold the funds in trust and not disperse anything pending the final Medi-Cal or Medicare lien, and then we satisfy it out of the settlement proceeds, and once that's done, a distribution is made to the client. There's different creative ways of getting around that because, we've had cases where Medi-Cal has taken a year to provide us the final lien amount because the client is still treating. Well, nobody wants to hold this settlement up for a year waiting for Medi-Cal. In that situation, we've had some insurance companies, like I said, we'll take the check, we'll put it in our trust account. We agree not to disperse it until there's a final Medi-Cal lien. And in that situation, typically there's an agreement to indemnify the defendant and the insurance company in case for some reason the lien isn't satisfied and Medi-Cal, Medicare, or whatever case may be, ends up pursuing a claim.
So you could put that arrangement. I'm sorry, Peter, go ahead.
Yeah, let me just an insurance company can agree to do whatever it wants to agree to do, but the question of whether it's obligated to do that is a very different question. I don't think an insurance company is obligated to provide all the money to the claimant and the claimant's attorney and trust them to live up to their promises of what they're going to do with it. So I agree with Dan that the first approach that he mentioned would be appropriate, which is to wait until you find out what the obligations are and then honor those obligations separately. There may be a situation based on the nature of the statutory lien that that the claimant will be entitled to at least a certain portion of the policy proceeds, and that would be appropriate to pay that portion. But I don't believe it would be appropriate to put control of the policy proceeds in the hands of the claimant and his or her lawyer.
Okay. Well, the next topic we were going to talk about is that the policy limit demand is reasonable if there's a likelihood or sometimes a substantial likelihood of an excess verdict, and it's phrased differently in different cases. Does it make a difference? Here's some of the cases where it says that CACI only says likely. Some of the cases say substantial likelihood. Dan, what's your take on that?
I think, likely, substantially likely, substantial probability. I think those are all basically used interchangeably, and really, in front of a jury, because ultimately, whether this determination will be made by a jury, I really don't think a jury is going to make much of a distinction between substantial likelihood versus strong probability. I mean, the issue is going to be based on the information the insurance company had. Did it appear at the time that a judgment would exceed the policy limits? I think where this may make a difference is on a summary judgment filed by the insurance company, where a judge could say, well, no reasonable jury could find that it was substantially likely it would exceed. I think that's really where this plays out. In front of a jury, I really don't think it makes much of a difference which formulation of that you use. And as you know, CACI 2334, which is the open limits instruction, uses the word likely. It doesn't say substantially likely or strong probability. It just says likely will exceed.
Right.
I agree with everything Dan just said, but let me point this out. While it may be that a jury or juror may not appreciate the distinction between likely and substantially likely, when it becomes a problem is if it ends up resulting in a jury instruction that doesn't adequately state the law. And so we're talking about one of several aspects of CACI 2334 that may not be consistent with the law. And at some point, there's going to be a challenge to a claimant that relied on CACI and the word likely and did not say substantially likely. And that challenge may end up with a reversal. So I think plaintiff lawyers, if you accept Dan's point, which I actually agree with, which it probably won't make a difference to a jury, it may make strategic sense for a claimant lawyer to allow the term substantial likelihood to be in there so that if they get their judgment, it won't be vulnerable to an appeal, because I think it's a flaw in the CACI instruction, and they should have followed the California Supreme Court authority that uses the term substantial likelihood.
So then we come to the second prong of CACI 2334, which is not only must the demand be reasonable, but the conduct of the insurer must be unreasonable in rejecting the demand. And that brings us to Minto and the evolution of 2334. Peter, you were going to give us a quick review of the evolution of 2334.
I'm going to make it really quick because I see that we're using a lot of our allocated time. So let me just say this. Under California law, the law that relates to insurance bad faith in the third-party failure to settle context, it is always, the Supreme Court on down have always held that you have to show that an insurance company unreasonably refused to accept a demand within policy limits. And the original jury instruction in California said just that. And that was a Badgey instruction way back in the days pre-CACI. And the Badgey instruction basically had the two elements. The two elements, as Arnie pointed out at the beginning of this proceeding, are the demand has to be reasonable and the insurance company's failure to accept the demand has to be unreasonable. Those are the essential two elements of a bad faith failure to settle claim. And those elements were listed in the Badgey instruction. Then CACI came along, and CACI actually accurately included those two elements. And then, for reasons that I would take half an hour to go into, and so I won't do it here, Justice Kroski tried to improve the CACI instruction because he felt it was not as favorable to the insurance industry as the law required. And in that process, things went back and forth and there were different drafts, and somehow the second element got omitted. And it's ironic because actually Justice Krosky was trying to make the instruction more favorable to the insurance industry, and the result of it was that it actually left out one of the critical components of a bad faith failure to settle claim, which was the second component that the insurance company, even if it gets a reasonable demand, it's not liable if its failure to accept that demand was not unreasonable. So that resulted in countless battles. I was involved in them. Dan was probably involved in them, where we would go to trial in these bad faith cases, and the plaintiff would argue it doesn't matter what the insurance company did, why it did it, whether it was reasonable or not. All that matters is whether the demand was reasonable. And so finally, the Pinto case came down and corrected that. And in fact, in the Pinto case, there were plaintiff lawyers that had a very large, at the time it seemed very large, these days maybe not so, but it was a $10 million excess judgment. And they made the argument that I just talked about, and they said, oh, no, it doesn't matter what the insurance company's conduct was. All we have to show is that the demand was reasonable. Who cares whether the insurance company's failure to accept it was reasonable or unreasonable? And the Court of Appeal reversed and ordered judgment to be entered in favor of the defendant insurance company because the plaintiff and the plaintiff's lawyer did not ask the jury to consider the reasonableness of the insurance company's conduct. Following Pinto, CACI 2334 was amended again, and brought back into the CACI instruction was the mandatory second element. That's the evolution.
Okay.
And I would add that to Peter's point about 2334 and the challenge on appeal. I believe, and Peter, correct me if I'm wrong, that Pinto actually went up on appeal on a challenge to a jury instruction. Is that right?
It did. Well,
on that issue.
Yes, that was the very issue that Pinto went up on appeal on, was whether or not the insurance company is entitled to show that its conduct in failing to accept the demand was reasonable. Correct.
So, well, what are situations where the demand was reasonable, but the demand was a reasonable demand, which was rejected, but the conduct was not unreasonable? Where do we get into those situations?
So again, this is, reasonableness is in the eye of the beholder. It's a deeply, deeply factual circumstance, but kind of the general, guidelines we can discern from the cases is, if it's just a mistake, the insurance company miscalendared, or there was confusion or a mistake in the claim number, and that's why there wasn't a timely response. But as soon as the insurance company figured it out, it's that, it accepted things like that. The court's going to say are probably, reasonable or not unreasonable. But where the insurance company kind of, if you read Hedayati, and Hedayati's factually, it's very, very dense. But the bottom line is, it was a horrific, horrific injury, and the insurance company was really lackadaisical about getting it resolved. It got a policy limit demand, I want to say the week of Thanksgiving, and the person that was in the office to process FedEx or UPS envelopes happened to be out that day, so the demand just kind of sat in the mailroom until the day after it expired. At that point, somebody picked it up and said, oh, a policy limit demand, handed it over, put it on the desk of the claim supervisor, who had happened to be left early that day. And so the court looked at that and said, hey, you know what, that's not reasonable. I mean, you really should have processes in place so that when a demand comes in, but your mail person's out, somebody is there to pick up the mail and deliver it to the right person. And if the claim supervisor is out that day, somebody is there to monitor the desk to make sure that when a demand comes in, it gets responded to on a timely basis. And so it's facts like that. And again, it's highly factual. So you really need to take a look at what happened and determine, was it just the insurance company being, non-responsive, understaffed, whatever the case may be, or was it just a mistake and they were trying to figure out what was going on? There was a mistake regarding the claim number. They couldn't figure out who the insured, or sometimes they can't get a hold of their insured to verify the permission to disclose limits, things of that nature. So you really have to read the cases and take a look at those factual circumstances, kind of get a feel for it.
Right. Peter, anything you wanted to add?
No, I agree with what Dan said. I point out that in the Hediotti case, the court didn't make a finding that the insurance company's conduct was unreasonable. It just said that there's evidence here that should allow these issues to go to the jury, because there's evidence that, if believed, might cause a jury to believe the conduct was unreasonable. But it really comes down to the difference between negligence, mistakes, inadvertent errors, and something that is at a higher level, which is the unreasonable conduct required to hold an insurance company extra contractually liable. And it is a higher standard, and it will be great if we can ever get some courts to weigh in on examples of conduct that does not reach that standard and is merely negligence or mistake, so that we can have more guidance on that.
All right. So I'm going to skip a couple of slides here and go to this one. Do you even need a demand? Can you find bad faith without a demand? Dan?
Yeah, so in very, very, very limited circumstances, the courts will allow a bad faith claim to go forward without a formal demand. And the cases, Boyd Court kind of sets out one of the guidelines for it, and then the rest of the cases kind of build on it. And the bottom line is, if the claimant indicates an interest in settlement to the carrier, and the carrier engages in conduct that prevents a settlement from ever being made, a demand from ever being made, in that situation, you may be able to plead a bad faith failure to settle claim, subject to proof at trial that, but for the insurer's conduct, the case would have settled. So just a couple really quick factual scenarios. In Boyd Court versus Amex Assurance Company had a rule that they never disclose policy limits. And the court said, well, if you never disclose policy limits, you're preventing policy limit demands from being made. And then the facts in that case was the claimant requested, wanted to know what the policy limits are because he said he wanted to make a policy limit demand. Amex said no. The court said that pleads a cause of action, subject to proof that had they disclosed the policy limits, the case would have settled. In Planet Bingo, it was actually a subrogation claim by one insurance company against the insured of another insurance company. The carrier denied coverage. The defendant's insurance company denied coverage. Before it denied coverage, it received a subrogation demand in excess of the policy limits. And in response to that excess demand, it denied coverage. And there was evidence presented to the court that in these subrogation claims, when a demand is made, it typically settles for the policy limits. And on that basis, Planet Bingo said the case can go to the jury on whether it would have settled. And interestingly enough, Planet Bingo was not even an excess exposure case. The insurance company ended up paying the subro claim, but the insured claimed that it went out of business because it ultimately got sued.
I generally agree with everything Dan just said. I just clarify that in Planet Bingo, the claimant requested to go to mediation to discuss settlement, and the insurance company refused to. And I think that's the critical factor in that case. The point being, if an insurance company if it does not allow the opportunity to discuss a policy limit settlement, then it may end up being liable even in the absence of a demand. And that's what happened in Boyd Court and Planet Bingo. But contrast that with whether an insurance company has some sort of unilateral obligation to tender the policy limit in the absence of a demand, and the law is to the contrary. There is no such duty. But while you don't have to tender the policy limits when you know or should know the claim is worth that amount, you cannot engage in conduct that effectively prevents the claimant from ever making a policy limit demand. And that's what happened in those two cases.
Okay.
And I agree with Peter's characterization.
What if the claimant proposes a stipulated judgment?
Yeah, this is an issue that's near and dear to my heart. So what are we talking about here? You have a case where the liability clearly exceeds the policy limits. It's a clear liability case. No question that there's going to be a judgment against the insured. The case is in litigation. And the plaintiff says to the insurance company, hey, if you agree to consent to have a stipulated judgment for X amount in excess of the policy limits against your insured entered, we will give the insured a covenant not to execute that excess judgment against the insured's personal assets. In exchange, the insured is going to assign their rights against the insurance company to us. And the defendant insured in that case says, yes, absolutely, I want to do the deal because I get a covenant not to execute. And the case is done. I don't have to go to trial. And the insurance company says, no, we're not going to consent to that, forces the case to trial, and then a judgment that is far in excess of what the stipulated judgment proposal has been entered. Now that judgment is executable against the insured, and there is no covenant not to execute. And the insured is sitting there going, well, wait a minute, insurance company, you forced the case to go to trial against me. I could have had a covenant not to execute. Now I don't have a covenant not to execute. And you never offered to pay the judgment. You said you're only going to pay your $15,000 policy limits. In that situation, is the insurance company's refusal to consent to the entry of a stipulated judgment and forcing the insured to proceed to trial, is that bad? That's what we're talking about. Peter and I have a really healthy dispute over this. I maintain that in controlling the insured's defense and maintaining an absolute right to consent to settlements, the insurance company has to exercise that right reasonably. And when the insurance company just says, no, we're not going to do it, and that ends up causing harm to the insured in the form of a judgment for which there's no covenant not to execute, the insurance company is liable. It may not be liable on a failure to accept a reasonable a policy limit demand theory, but it can be held liable on other bases, including unreasonably exercising its rights under the policy to the detriment of the insured, placing its interest ahead of the insured's interest. I note in Dora versus Deerbrook, the district court said that is not a viable cause of action. You can't sue the insurance company. In Spradlin versus Geico, which is my case, the Central District punted on that issue, denied the Geico's summary judgment on the issue, but didn't really decide it. Dora versus Deerbrook was appealed to the Ninth Circuit, affirmed on appeal, but the plaintiff didn't appeal that issue, so we don't have a ruling from the Ninth Circuit on that. Spradlin ended up resolving, and so this is kind of up in the air.
Well, I would disagree with the last point to the extent that every court that has ever published a decision on this issue, and there have been many across the country, has said that this approach is not a way to open an insurance policy. Let me start by saying that I don't have any problem at all with a claimant proposing a stipulated judgment with the terms that Dan outlined. That may be something that an insurance company thinks makes sense and is willing to agree to. The issue is, can an insurance company be sued for bad faith and for the amount of an excess judgment by not agreeing to it? And the fact of the matter is, it's not an obligation that exists under the policy. Insurance companies have an obligation to try to settle within limits in exchange for a release for their insured. But this is what Dan is proposing or outlined is not a settlement, doesn't provide the insured with a release, all it really is doing is asking the insurance company to agree to the amount of damages that the insurance company will then be sued for in a subsequent bad faith case. I don't believe there's any contract provision that would require an insurance company to do that, either express or implied, and the courts have agreed that that doesn't fall within the narrow exceptions that must be met in order to sue an insurance company for bad faith in the failure to in the third party context. So we do have a disagreement. I agree with Dan's characterization of the cases, though. The Spradling court simply noted some reasons why it wasn't going to decide the issue and decided to punt on it. But among other reasons, it's a situation where the insurance company is asked to enter into an agreement that, of course, the insured has no downside, so they'll just agree to stipulate to it, and they're essentially stipulating that they won't be sued for the excess amount. They're saying, yeah, I won't be sued for the excess amount, but I'm going to maintain and be able to pursue and or assign my bad faith claim and sue the insurance company for this excess amount that I've never actually been subjected to. Now, if there's an actual judgment, then an insured can do that. But I don't believe the insurance company has to agree to set the damages for a bad faith case in advance of an actual trial. And that's why there's a lot of room for disagreement on this issue.
Okay, well, I think that's our time is up. I don't know whether there are any questions here. It looks like there are a few questions. Let's see, the first question is, does this statute apply to personal injury matters, only to personal injury matters? Does anybody know the answer right off the top of their head? I think
it's in 999.5.
in 999.5,
Let me see.
it says the chapter shall only apply to causes of action and claims covered under automobile, motor vehicle, homeowner, or commercial premises liability insurance policies for property damage, personal or bodily injury, and wrongful death claims, is what the statute says. Here's another question. If in good faith you dispute liability in a premises liability slip and fall case, de minimis or open and obvious, do you risk a bad faith determination by refusing to tender limits in a case where a plaintiff has astronomical medical bills?
I think we addressed that. An insurance company doesn't have an obligation to unilaterally tender in that scenario, but an insurance company may have an obligation to accept a demand within limits under that factual pattern.
Can you ask the carrier to leave some small amount of money to protect the duty to defend against possible future claims?
You can. So that addresses a situation where you got a policy limit demand that exhausts the policy. There's no more duty to defend. Yeah, you can, as a plaintiff, you can make a settlement demand that leaves a penny on the policy, and that penny would allow a duty to defend to exist. Now, indemnity would be limited to that penny, but at least the insured would have the benefit of counsel to defend them against the other claims. So yeah, you can structure it that way. I'm not sure that the insurance company's rejection of a demand that's structured that way, that leaves a penny or $10 or whatever it is on the policy, would be deemed unreasonable, but you can certainly structure it that way.
Yeah, Peter, I'm assuming you're saying that the insurance company does not have an obligation to accept such a demand.
Well, if the demand would exhaust 99.9% of the policy limits in favor of one claimant and leave the insured exposed with only $1 of indemnity to a bunch of other claimants, it would not be a reasonable demand. So that's how I was interpreting the question. Now, can a demand be made structured that way? Absolutely. But what we're dealing with here is whether the insurance company will be liable for not accepting a demand like that. And that goes back to the issues we talked about earlier.
How do you resolve the comp lien negotiated after or before?
it could be, you could do it either way. We've had cases where we've agreed with the comp carrier that it's a minimal policy. We're going to do a joint demand, get the 15,000, then we'll negotiate what the lien is afterwards. Or we've agreed that, a third, and then make the demand. It's really up to, the plaintiff, attorney, and the comp carrier.
So I'm not sure how much time we have for these questions, but I will keep going for the time being. In this situation where demand is reasonable and the carrier nonetheless thinks liability is in dispute, is it not unreasonable to refuse the demand?
The issue there is whether the information presented to the insurance company does or does not establish a likelihood or substantial likelihood that if they don't settle within the policy and it goes to judgment, there will be a judgment in excess of the policy limit against the insured. That's the test. And so, as Dan and I have been saying all throughout the hour, every case needs to be evaluated on its own merits. And so it would depend on the evidence. There may be circumstances where the liability is in question, but the damages are so significant that the risk is too high for the insurance company to gamble and go to trial. There may be circumstances where that could impact whether the insurance company would be liable. There may be circumstances where there's just such a minute possibility that the insurance company would ever be held liable at all, that it would be reasonable to reject a $15,000 demand in a catastrophic injury case. It just all depends, and it's not something that you can answer with a blanket rule.
I'd agree with that.
Can a coverage issue with ROR dispute equal unreasonable conduct?
No. An insurance company has a right to assert a reservation of rights. That's not a withholding of policy benefits. So the whole concept of bad faith is whether the insurance company is withholding the payment of policy benefits unreasonably. And asserting rights under an ROR is not a withholding of policy benefits. In fact, there's a case called Griffin to Watering that addresses that and says that the insurance company's reservations of rights does not mean that they're withholding benefits. It just means they're reserving their right to dispute whether benefits are owed in the future.
Reservation rights can trigger a cubis conflict, which would entitle the insured to independent counsel. But Peter's right. Insurance company is entitled to unilaterally reserve rights, including to reserve rights to seek reimbursement from the insured.
They're not entitled under Johansson to make a decision on settling the claim based upon a coverage issue.
They are entitled to, but they're strictly liable if they turn out to be wrong.
Right.
That's a distinction, which is probably worth noting, which is that if the reason that the insurance company does not accept the policy limit demand is because there is a coverage dispute, and it turns out that the insurance company is wrong in that coverage dispute, that is the one circumstance under California law in which an insurance company is in fact strictly liable. But if the basis for not accepting is anything other than coverage, then that strict liability rule would not apply.
Can you make a claim against the insurance company for bad faith or open policy where they offered the policy but are unable or unwilling to provide proof that the insured was not driving in the course and scope of his or her employment at the time of the accident?
Well,
so that again, just going back to, we talked about it all depends on the circumstances. If the demand requires a declaration from the insured that they weren't in the course and scope, and the insurance company attempts to get it but can't, then no, then that's something that's beyond the insurance company's control. However, if the demand requires it and the insurance company blows that requirement off and doesn't go to its insured, doesn't try to find out the information, then possibly, given, depending on the circumstances, that could be deemed unreasonable conduct.
I agree with that.
Okay, when dealing with employment liability insurance, EPLI, are there any special considerations different from what we've reviewed already? That's a pretty big question.
Yeah, I think the rules we talked about apply across the board to all liability policies and all settlement demands. So there's something unique in EPLI, maybe that it's a burning limits policy. So there may be an additional consideration by the insurance company of diminishing limits if they don't accept the demand now. But beyond that, it's all the same. It just depends on the circumstances.
Right. I have two more questions here. Talk about the situation when a carrier tries to accept a policy limit demand, but does not meet one of the reasonable conditions. Well, you just talked about one, Dan.
Yeah. So yeah. So and I think Hediati, if you read the facts of that case, had to do with not getting a declaration from the insured regarding, I think, his assets. The carrier could be liable for liable in excess of limits where it fails to satisfy one or more of the conditions in the demand. Caveat is the insurance company has to act unreasonably in failing to do so. So, like we talked about, if the insurance company can't get the declaration because the policyholder won't respond, then they haven't acted unreasonably. They tried, they couldn't get it. So again, comes back down to the factual circumstances of each case.
And last question, does reasonable demand include providing liability video evidence?
I don't think you're required to do it. To the extent there's you want to provide it, to the extent it would help the insurance company, you certainly can provide it. But there's no requirement that you provide. I mean, the statute, especially the statute, doesn't require you to provide anything in particular. You just have to have information that is sufficient for the insurance company to evaluate the claim.
Okay. Well, we got two more questions that came in. Are policy limit demands made during pending litigation analyzed pursuant only to case law and reasonableness of demands without any consideration of 999's requirements? I think the answer is yes, they're independent. 999 only applies prior to litigation.
I would agree that that 999 doesn't apply, but I do think that 999 reflects the legislature's determination of what's reasonable, and so it may indirectly have some impact on a demand that was made during litigation. It just depends on what the circumstances are, but it doesn't govern it.
So let's see. Do you think the carriers following legal advice cover them from being seen as unreasonable?
It can.
Go ahead,
It depends on the circumstances. So again, it's an objective standard. Was the insurance company's failure to accept the demand reasonable based on the circumstances that existed at the time? And we're setting aside the coverage reason that we carved out, in which there's strict liability. So putting aside that, if they're relying on an attorney's advice regarding an issue that would impact whether they should accept a demand, then that could be reasonable and that could be a defense. The California law recognizes a, quote, advice of counsel defense. That's a recognized defense to bad faith liability. And so depending on the circumstances, it could apply.
Yeah, the only thing I would add to that is when the insurance company asserts advice of counsel as defense to a bad faith case, it waives the attorney-client privilege with that counsel. So typically in open limits cases, that's not much of an issue because the assignment gives you also the attorney-client privilege from the insured. But let's say the insurance company is relying on coverage counsel to advise it on responding to a demand. If the insurance company attempts to defend its decision by saying it relied on coverage counsel, that will waive the attorney-client privilege with respect to what coverage counsel said. So that's always a consideration in when asserting that defense.
Well, what if there's 500,000 in limits and there's a $500,000 demand and defense counsel says the case is only worth 250, and so they reject the demand?
That is evidence that goes to the issue of whether the insurance company's failure to accept the demand was reasonable. That is definitely relevant evidence that can be considered along with all the other evidence in making that determination.
I agree with that.
Is it a reasonable demand if it was clearly written by an attorney, but claimant is claiming to be unrepresented? Which does happen.
I should probably let Dan answer that question, but go ahead, Dan. You've probably never seen anything like that, have you?
Not a single time. I think it's a reasonable demand so long as it meets the definition of what a reasonable demand is, whether it's sent by an attorney or a claimant, or authored by an attorney for a claimant to send. The implied covenant of good faith and fair dealings applies to insurance companies. The issue is what the insurance company does with the demand, not who authored it.
Well, the statute 999 does not apply to people who are unrepresented. Would that
Yeah.
be unrepresented if the claimant had some help from an attorney to write the letter?
That was the question that I understood to be posed, and that is an issue that has not been decided in California. And an argument could be made that because the insured actually had counsel, which means, I mean, think about it. Why does 999 not apply to unrepresented claimants? It doesn't apply to them because they don't go around and read statutes. They don't know what their legal obligations are. And so they're not bound or shouldn't be bound by a statute with all kinds of detailed provisions regarding how you do and don't make a settlement demand. But a claimant who has consulted with an attorney and who writes a letter pursuant to the attorney's advice on what to include and not include, an argument could be made that that is not a unrepresented claimant because with respect to the demand letter and the components of the demand letter, the claimant was represented. Having said that, that's going to be a subject for the courts to decide in the future, and there is no law on that today.
So what's the scope of the privilege waiver in an advice of counsel defense?
You waive all communications that relate to the advice in question, and sometimes an argument will be made that the waiver should go beyond that, and that would be decided by a judge on a case-by-case basis, depending on what it does not mean that every communication you've ever had with a lawyer is suddenly disclosable, but there are arguments about whether more should be disclosed than just the communications relating to the specific opinion. So there are fights about that.
Okay, this will be our last question. How about in terms of a release that are in direct conflict to the conditions of the demand? An example, plaintiff will not release the defendant's attorney, and the release includes the defendant's attorney.
Yeah, that goes to, there's a case called Berkman versus Mercury, where the Mercury was held liable in excess of policy limits because it refused to make changes to a settlement agreement. And then the case called Hodrodge that followed Mercury that talked about what happens when the insurance company accepts all the material terms of a settlement demand. But then there's a disagreement on the scope of the release agreement. And Hodrodge in court said, well, there's a settlement there, even though you didn't execute a release agreement. But the short answer is yes, the insurance company can be held liable if it refuses to make changes to the settlement agreement. But again, it's a case-by-case basis. I mean, what were the changes? How many did the demand go out and say, hey, we don't want it to include X, we don't want the release to include X, Y, and Z. And the insurance company sends a release that has X, Y, and Z because that's the standard release the adjuster sends. And then the plaintiff says, oh, open limits, bad faith, doesn't give the insurance company an opportunity to make changes to the release agreement. In that situation, there's probably a pretty good argument that it's not unreasonable. The insurance company was just following what it does, and had the plaintiff requested changes, they would have been made. But if you have a situation where changes are requested and the insurance company repeatedly says no, the situation could be different.
I agree with Dan. And just to clarify what the issue is, if the insurance company inadvertently provides a release that doesn't perfectly comply with the terms of the demand, that may not constitute bad faith. And in fact, there are cases that can be found online where courts have refused to hold insurance companies liable for bad faith under that circumstance. However, if a reasonable release term is demanded as part of a settlement by the claimant and the insurance company knowingly refuses to provide that reasonable term, then that could qualify as unreasonable conduct that prevented the case from settling and opens to policy.
Okay. All right. Well, that's the end of our presentation. Thank you, Peter. Thank you, Dan. It's been a great discussion, and good day, everyone.
Thank you, Arnie.
All right.
Thank you.